So, continuing the discussion on issues related to intellectual property right, we have seen that there are different issues related to intellectual property rights today, and as a part of the 4th week course, this particular lecture is discussing about how intellectual property rights today is a matter of great commercialization and unfair competition. So, we are going to really focus on the discussion today. The brief outline of this discussion is the introduction, commercialization. We will try to explore some of the instances, then the rules, the global rules of unfair competition, and then concluding remarks. So, when we say commercialization, what comes in our mind? It is basically a process which introduces a new product or technique of production to the market. So, intellectual property right is one of the major helpful tool to commercialize the product, because when a product is added with new intellectual property with a new intellectual exercise, then the product is really capturing the market, and firms are trying to commercialize those intellectual properties to the market. And intellectual property is not only the legal asset, but it is really having one of the commercial value today. So, commercial benefits of an intellectual property right can be extracted through selling, licensing, or setting up own commercial venture. Rapid technological progress, which is one of the recent trends, especially in newly emerging economies, and also in some of the developing countries, we are finding that there are certain technological progress going on, and which has very much impact on the commercialization of those new inputs, which is used for the making the new output to the market, and those outputs are commercialized today, and it has a very global demand, and such commercialized intellectual property rights are the matter of a globalized market. So, the commercialization of intellectual property is including the innovation process of technology and inventions, and these are the essential for transforming inventions into profitable marketable products. However, in the process is not so easy. The entire process of commercialization includes various steps, and it is complex and entails to a large extent specialized efficiency, skills, and professional knowledge. So, for any successful commercialization of intellectual property right, it is indeed important to have a proper invention, proper innovation, and the ultimate and critical stage of the innovation process is the marketing and commercialization. The fact is that most of the patents, most of the commercial intellectual property, if it is not commercialized, the market value of those patents and market value of those intellectual property rights, the commercial value of those intellectual property rights are not, if it is not exploited, it means that patent has it basically lost its value, which is linked with the market and commerce. So, that is a setback for the commercial for the patenting system if it is not really commercialized. So, ultimate goal of the firm's research and development activity today is to have some output which may be commercialized. So, the entire commercialization process is it can be divided in 4 phases, as World Intellectual Property Rights highlights these 4 phases as the generation of ideas, first phase, the development and design as the second phase, prototype and pre-production is the third phase, and the fourth phase is the final production, marketing, and commercialization. So, and each phase is really having different steps, different level of preparation. So, commercialization cannot be without a strategy, as we have seen that different stages it has to be exercised, and so there are certain strategies to commercialize the final product. the first is setting up its own owner's personal manufacturing and marketing unit. The second is to authorizing some of other producers or some other people to get the license for the marketing and manufacturing. And the third is to really having the patent rights, and then any other problem and associated issues, if it is available, then it is also the responsibility of the patentee or the intellectual property owner to find out the strategy to solve the issues related to commercialization of those patent rights or any intellectual property rights. So, the process of commercialization includes the knowing what type of market is there to launch a product. For example, if there is a pharmaceutical product, you have to find out that what type of market, in which capacity you are going to launch the product, how many customers you are going to get it. If it is electronic product, before that you have to have a, before launching the product, you have to have a survey to find out that what type of market exists, what type of demand exists for your product, and locate and identify the customers, because how you are going to reach to the customers without locating the customers, without identifying the customers, it is not so easy to really reach the reach with the commercial products to them. And then invent and innovate. When you have you are knowing their strength, or if you are knowing the current condition in the market, when you are aware that what type of demand is existing, where is the consumer, what type of consumer you are having, then you are more sure about your invention and innovation. So, and then you have the invention and innovation, it is your responsibility, the inventor's responsibility to protect the intellectual property. Because we have seen, when we were discussing about the issues related to intellectual property right, we have seen that there are unfair usage of intellectual property rights on a very large scale, not only in the patent related areas, but also related to traditional knowledge, related to biotechnology, related to the plant variety. And so, it is the responsibility of a particular owner to really look for protecting the intellectual property. And then when you have these process evolved, then you have the right to commercialize and to set up a business. Any such drawback on your process of commercialization is going to really get you a setback, and you are not really able to continue in the market. So, for example, if we are talking about the commercialization of patents, as we know that patents are extensively created means that promotes innovation. And when intellectual property, this IPR grants the holder this particular patent, is granting the patent owner the limited right of exploiting, and allows. Why it is limited right? Because you have a time framework and you have a limited time, within that time only you are going to exploit the market. And then the owner is allowed to venture the invention by manufacturing, using, selling, or processing, incorporating the technology covered under the patent ownership. So, the owner may also allow the invention to be exploited by others over a set period of time in return of fair reward, which is named as the license fee, to maintain the R&D cost and others. So, there are certain facts which is important to learn today, which is related to patents. According to the Ted Sussman commercialized patents Stanford Law Review 2010, about more than 50% of all the patents granted for inventions are never commercially exploited in United States. IBM was granted approximately 67,000 US patents during 93 to 2012. It has received 6,478 patents in 2012, outpacing the aggregate of Accenture, EMC, Amazon, Intel, Apple, Oracle, Symantec, and HP. IBM owns about 50,000 active patents, which makes it one of the largest patent owner company in the world. So, we find that due to the huge value of commercialization of these patented items, some of the firms are so strong in patenting that they are really working hard to go ahead with new and more novel ideas to patent it. So, some of the statistics which is related to United States we can see here in last 5 years data 2010, 11, 12, 13 and 14 and 15, 6 years data, we are finding that the number of patents in 2015 compared to 2000 is very high, because in 2015 US is about to reach to the level of 3 lakhs patent. Out of 3 lakhs, 1,40,969 patents are by the US origin, while the 1,57,438 patents are related to the foreign origins in 2015. So, this shows that the statistics shows that there is a rich patent awarded in United States, and this type of data shows that patent granted in United States and trademark offices are convincing us that there are commercial value involved, even if 50% only hardly 50% patents are being marketed, but nowadays there is a again rethinking on these patented items, that before going for the patent applications, they are also finding that what type of real usage of those patented items are for the marketing purpose. Because the importance of commercial value of intellectual property one can also find today, which is the case of copyright theft. In the recent case in India, very recent, on 15th June 2016, a copyright theft case with the Mumbai Police Crime Branch was filed due to the leak of movie on the internet before the proper formal release. So, one side we have seen that how number of patents has one of the important implication, but here we can see that apart from those legal implications for business, if unfair practices are already on, that in case of investors, especially for the copyright material, it is really going to have a very different level of challenge, because those intellectual property rights, especially the copyright materials, are having a huge market, and there is a parallel market which do not want to really pay for the copyright holders, and they want to really have a free access of those films, those audio, those videos, which can be the matter of piracy. So before release also the film was available, and this type of incidents are not single, but there are large number of such incidents, not only in India but also in other countries. So other intellectual properties appear to be very significant when successful innovation compromises captivating a new product to the market. For the marketing process, industrial design and trademarks play a very critical role. In our previous lecture also we have seen that certain industries, especially fashion industry, textile industry, and electronic and other industry, they are using this industrial design and trademark in a very great sense to acquire the market, because these intellectual properties are helping them to really go ahead with the market. However, for launching new products in the market, a trademark is again one of the effective tool. So some of the instances of trademarks and other intellectual property rights which can be seen here, that trademarks can be extremely successful in exploring, penetrating and entering into the new markets of product, new markets for products. For instance, Honda captured the advantage of its brand name in motorcycle manufacturing to really reach to the United States car market. Combination of various types of IP tools such as patents, industrial design and trademark can be traced by the example of the vacuum cleaner that offers a good case of commercialization of different intellectual properties. So apart from these examples, we can also see the example may be the aspirin, which was developed by Felix Hoffman in 1897 while working for Bayer company in Germany and was patented in 1899. Since patents are granted for a limited period, the Bayer company resorted in endorsing a trademark for its new drug. After the expiry of patent, Bayer started benefiting from the selling of aspirin by trademark aspirin or in the circle. So, the company has also exploited the dual way intellectual property strategy for its Cipro drug used in the cure of infections. So, trademark can also assist in enlarging the commercial benefits outside the life of a patent. If so, this is the case of dual intellectual property. The product was previously got the patent owner awarded, and now the company has filed a trademark registration for that, and then dual way of intellectual property strategy help the company to really continue their monopoly in the market, because such a strategy is having the commercial importance. So, intellectual property may be separately or may be a combination of patents, industrial design and trade secrets, copyright or trademarks, and it can be used to assist the commercialization of any new products. Higher profits, premium price or significant market share can be sustained through the strategic use of a combination of intellectual property rules. So, what is unfair competition? Because in the first part of this lecture we have seen that there is a huge value, high value involved in the commercialization of these intellectual property rights. But what is basically unfair competition? Paris Convention 1883 article 10 VIS categorizes unfair competition into three level: confusing causing acts, damaging reputation and misleading acts. So, if a firm really wants to, suppose there are two firms, a firm which is having the ownership, of intellectual property, firm A, and firm B is not having ownership of IP. So, suppose we have two types of firm, one having the ownership of IP and the second one not having the ownership of IP. And if this firm B is trying to compete with firm A, because firm B is not having ownership of intellectual property, so the firm B will try to copy the trademark, maybe copy the trademarks, or maybe trying to have the infringing of the patent rights, trying to really produce a product which is similar to the patented products, try to steal the composition and try to peep into the secrecy of a producers, and try to damage the reputation also, or try to confuse the customers with the similar symbol, similar logo, similar type or the name and brands. So, finally, the B is having the unfair competition with firm A. So, firm A and firm B, firm A and firm B is not at the level of equal platform. They are not at the equal platform because firm A has investment, in IP, ownership of IP, cost involved, cost in IP, but firm B has no cost or very less cost in copying. So, firm B is trying to compete but the firm B is not trying to compete with a fair means, but firm B is trying to compete with unfair means. So, this is the firm B is the example. Firm B is an example of unfair competition. Firm B is an example of unfair competition because firm B is trying to copy the trademark, firm B is trying to copy the symbol, trying to copy the slogan, trying to copy the brand name, and maybe trying to infringe the patent rights, or whatever means they are trying to adopt, they are doing it. So, ultimately the firm B is not supposed to do that, and the Paris Convention 1883 providing the guidelines in this regard. So, unfair competition is any action or practice taken out in the way of industrial or commercial enterprises opposed to honest practice is regarded as the act of unfair competition. So, if you are completely opposite to the honest practice, like in case of firm B, contrary to the honest practice has become the crucial criteria for defining unfair competition. So, firm B is in the court of law, if firm B is proved that they have copied or they have used some other formula or some other existing intellectual property for the production of something to the market, in that case firm B will be caught and punished and liable for the penalty. So, the Paris Convention 1883 safeguards a member against unfair competition by making it binding for the other members. This commitment is underlined by Article 2 of the TRIPS and obligates members of the WTO to abide by the Paris Convention. So, apart from the Paris Convention, the competition law also exists in countries which is aiming at prohibiting the strategy of the firms and big corporations to reduce competition and monopolizing the markets. Three broad laws are anti-monopoly law, anti-collusion law, which is named as the cartels, and non-competitive merger control law, which is the part of the competition law exists in most of the country today. And this shows that apart from the Paris Convention, a domestic law is also available to control certain issues related to monopoly, collusion and competitiveness, but that includes the intellectual property rights issues also, because if certain firms are trying to really make something very non-serious and unfair to the existing firm, which is really having a fair and very authentic intellectual property available, in that case certain competition law is there to prohibit those activities. So, converting an invention or innovation into a marketable, to a commercial product involves the strategy of a complete thoroughness, which aims at recognizing significant legal and commercial risk and application for and acquiring of the proper selection of intellectual property rights. So, we have seen that some of the firms are very smart enough to have the dual strategy of intellectual property, and and some of the firms are really active and smart to do that. Some of the illegal firms, like in case of firm B, we have seen that firm B is trying to have a very unfair competition and using the tools to really acquire the market. That strategy is not a fair strategy, that strategy is not a competitive strategy, but these are the strategy which is very much unfair, based on the unfair competitive motive. So, it also requires formation of a strong business organization and a system of license agreements with potential investors, manufacturers and distributors. If unfair competition has to be, then you have to have a strong business organization and ethics in a system. A system of license agreements should be very much depending on the mutual respect and confidence, and then only manufacturers and investors and distributors can really work for a very competitive, fair competition and to reduce the unfair competition. So, this if somebody really wish to boost the IPR protection, without boosting the IPR protection, entrepreneurs cannot really commercialize the products in the market, because if the protection system is weak, the firm who is really having, or the entrepreneur who is really having the intellectual property rights ownership, they are not sure that how long they are really safe and secure in protecting the rights. So, intellectual property rights are essential for encouraging innovations, but it can create monopoly, but the competition law and certain obligations in TRIPS agreement really provides a very wide range of controlling such monopoly power also. I hope this discussion, which is the last part of the course, is going to help you to link it, to link the previous discussion on issues related to intellectual property rights and why today lots of conflict and lots of challenges are on the way, because intellectual property right is not only a legal right, but it is also one of the commercial value involved in the intellectual property protection, and that is why the world is really active and really smart enough to have the intellectual property rights with a proper strategy, and some of the economies are really working hard to control their intellectual property in a much better way. Thank you.